Okay.
Thank you. Just pick on.
I can't sure clear. First set.
It's to order some.
Take a look at the top size. Kids and judges.
There's no hard pass.
It doesn't say.
Okay, where's this? All right, is the attorney here for Jeffrey Guerrero?
Yes, I am.
All right. And the attorney for Mia Hermio?
I'm present for John St. Heinrich, Your Honor.
Thank you. And the attorney for Yelani or Adrien Harper? The attorney for Tyler Millette. State on that case, he was supposed to plead on the misdemeanor. Do y'all know if that was accomplished?
I don't know. I can check in.
All right, thank you.
Gotcha.
James Davis, the attorney for James Davis.
I'm trying to get a one judge.
Thank you. Michael Keating.
President, Your Honor, it's going to be a plea judge.
All right, thank you. Patrick Washington. Thank you. Jaylen Ross. Thank you. John Skinner.
I'm present for him. That will be a plea.
All right, thank you. Justina Sauceda. We'll see if she made it.
Yes, Judge. No.
All right, thank you. And the attorney for Luis Beltran, I think they're still in trial. All right, thank you. All right, and Mr. Osterdorf, once you're ready with, it's Leslie Martinez.
Yes, I'm ready. I'm prepared to preparing.
All right. So on this case, was she on a PR bond?
No, Judge, when I checked yesterday, she was still on the bond. The young lady over here verified is David Sawyer. I think it's anytime bail bonds out because that's how I assisted her when I got appointed back in April, not
Okay,
April. It would have been August. I was appointed in August 24th. It's all on this paper showing my involvement in the case as far as appointed. And it looks like that your warrant was issued on 9/11 a.m. according to the district court's printout. And I remember she called me around 9:35 on my phone. I saw it. She was asking for directions. She was in the courthouse because I I heard her talking to a bailiff. I mean, I don't think it was here. I think it was somewhere down on the first floor.
Mhm.
And I was telling her where you were on the other, you know.
So what are
end
you
of the-
requesting?
Well, I'd like to get her out because I don't think she has anything but a prior, I may be wrong. I know she had a misdemeanor I was appointed to that's
All
been
right, State, do you
dismissed.
want the court to lift the judge's warrant or no?
We're not opposed to it, Your Honor.
All right. So what I'm gonna do then, I'm gonna lift the judge's warrant and she will need to be back here. I think she'll be released. She'll need to be back in court on Monday at 9 a.m. if
We'll
she's,
be here.
all right.
Because I yelled at her, tell her.
I'm sorry, Tuesday.
Okay.
Tuesday, yeah.
'cause Monday-
Yeah, yeah. Do you want to take?
I think.
Yeah.
I can look at
I think
it.
it is, I bet you it is.
What?
You know, in fact, I figured out that's the only place I do anything. Is in my head. Thank you, Judge.
You're welcome. All right. The party's ready on Mia Hermel Herrera.
That's right, Your Honor.
Alright. All right, where's your client?
It's just supposed to be brought over from Bear County Jail. Ms.
Okay.
Herrera, yeah.
All right, we'll wait for them to bring her out. Who is here on Adrien Harper? All right, come forward. Hello.
Hello, ma'am. What side do you want?
Oh, you're on this side.
This is their case. He didn't apply.
On the other.
Yeah, he's number one. It's a new case.
All right.
My wife.
So on this case, what are we here for?
Motion to set bonds.
All right, state, are you ready to proceed on the motion? All right, did you confer with the state on the bond?
Yeah, it just turns out that they don't have any labs yet on the new number one. That's the only alleged violation that we could go on.
Well, I have an indictment here. The case you have it set under is the motion for bond I have is 2024. Ah, that's the motion to revoke.
Yeah, yes.
And the allegation in the motion to revoke is the
New
new number
number.
one
Yeah,
and also the failure to submit to drug testing.
yes, which he rescheduled and it didn't take passed.
Well, I mean, you know, that's something for you all to present witnesses. All right, court is calling 2024 CR 1108 State versus Adrien Harper. Can I have parties announced?
Jason Garrett had the mistake.
We're not approving you for the accused.
And are you Mr. Harper?
Yes, ma'am.
All right, so according to this, the defense has filed a motion requesting bond be set to you. For you, you're entitled to a bond because I believe this is a deferred adjudication.
It was.
All right. And what bond are you requesting, counsel?
Well, the original bond was at 3,500, so I think the standard course is to double the bond.
No, I mean, what ends up happening is what bond can he make? And then the court makes a determination on whether or not he will actually appear if a bond is set. So
Oh, well,
what, you
he's-
want to ask him about the bond amount he's able to make?
yeah,
You want to raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Adrien Harper.
All right, you may proceed.
okay, Mr. Harper,
Yes, sir.
how much are you currently employed?
No, sir.
And do you have any resources that you could make a bond with?
Yes, sir.
And what level of bond would you be able to pay, let's say 10% of whatever she sets it at?
Yes, sir. I was comfortable with, well, my understanding was gonna be double of 35, so 7,000 I was comfortable with.
And you'd be able to afford $700?
Yes, sir.
And well, we requested, you said it's 7,000.
All right. Any questions? All right, State, what are you requesting?
State does, I mean, my go-to is doubling the bond, so $7,000, this I think would be appropriate.
All right, this is what the court is gonna do. The court will set your bond. At $7,000. I'm going to order regular UAs. And have you ever had any type of mental health
Yes, ma'am.
illness in the past?
Yes, ma'am.
All right, and I'll do a referral to Center for Healthcare Services. And then on the motion to revoke, do we have a court date for that yet or no?
Judge was set, the 20th.
All right, so this is going to be set for a contested. And it's going to be set June 5th.
Thank you, Judge.
All right, is there anything else?
Nothing further.
Give him a reset form for June 5th. Oh, your excuse.
Thank you, ma'am.
Judge.
You're welcome.
Here, yeah, just sign off. Right there.
Defendant.
Yeah. Unless you got a law degree and you represent yourself.
Could I have you?
Yeah. All right.
All right, thank you.
Now, are they gonna come to my office and be cashing the bond?
I'm gonna call him as soon as we get back.
Okay, so it'll be $720. Then. Well. Here you go. Thank you.
Thank you so much.
And.
So they're called.
All right, who's here on Jaylen Ross?
Can you recall it real quick?
Sorry.
Can you recall it real quick? Need a few more minutes.
All right.
Sorry, thought we were ready.
Looks like they did leave yesterday. Thank you. Thank you, Judge. You're welcome. I don't know if they'll come back for this, but. No, it's okay. Thank you.
What do you want him to do? Straight on the floor. What are you doing here?
Being the shot right
Hey, there's Rob. Hey, sir.
Portman, move over. Justina, move over. Sorry? You talked to?
Okay, I can go right there.
¿Qué pasó? Quiero. There's no. There's no manera. Okay. We don't need that. Can you go to the back of the car? I don't want to see what's. Because you're just in the moment. It's down there. I don't know, Judge, you still not mullet?
Millette has been dismissed.
Yeah, he's done.
Please let him know his case was dismissed.
He knows, Judge, it's just that he's still downstairs, we're trying to.
No, I mean, let the defendant know.
Yes.
Okay, all right, awesome.
Yes, he was kind of upset why he hasn't been taken back.
That's what you see.
Now, here, done.
Oh, but she's gonna get out of jail.
I'm not sure if they make it under the pen, but for example, you can check the kind of it was like one, your mom, right? Yes. He's done, so you should be able to.
Oh, about 2 in the morning.
Yeah. I called my mom. Yeah.
2 in the morning. I'll call you.
Thank you so much.
John Skinner. Court is calling 2025 CR 004-504, State versus John Skinner. Could I have parties announced for the record? State.
Jason Garrett, Your Honor.
Excuse me. You all need to whisper. If you cannot whisper, you need to take it to the other end.
James Hunt for defense.
And are you Mr. Skinner?
Yes, ma'am.
Counsel, Have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Skinner, Mr. Skinner, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Ms. Skinner, Mr. Skinner, I'm sorry, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 2, 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Skinner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Did you review, I'm sorry, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're asking that there be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
ma'am. Sir.
State any evidence.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right, so everyone in the box, does everybody know how to whisper? If you don't know how to whisper, then you can't talk in the box. I keep telling everybody, whisper. So if you can't whisper, then don't talk. All right. Are you waiving your right to PSI?
We are, Judge. There is one thing I'd like to address.
Yes.
The fine, my client formerly was a landscaper. I
Mhm.
think he's a little underemployed right now, asking that half the fine be probated.
Okay. So do you have any children?
Yes, ma'am.
What are their ages?
20, 16, and 14.
All right. And do they live with you or no?
It's too young.
All right. And who else is in the home besides you and the children?
Yes. Mother-in-law.
All right. So where's their mother?
She's Right now, I don't know what she's there right now.
For the last one? Oh, let me, okay. I'm sorry?
She's here too, but I mean, at the moment, I don't know.
All right. And if you're drug tested today, what are the results going to be? All right, what are you going to be positive for? And what else? All right, you shouldn't be taking care of children and using marijuana. You understand? So have you ever had any prior mental health issues?
No, ma'am.
How far did you go in school?
11th grade.
Why didn't you graduate?
And first child, I started looking for work.
All right, this is what the court is going to do. The court is going to sentence you to a $2,000 fine that will be probated, 3 years deferred adjudication, 200 hours of community service restitution. All right, probation, are you able to hear?
Ma'am, I'm sorry.
Are you able to hear?
Yes, ma'am.
All right. There's going to be 200 hours of community service restitution, minus 100 hours for parenting classes. So I'm going to require you to complete parenting. There's to be 100 hours will be deducted if you complete trade school or some higher level education. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. TAP evaluation, out of custody, follow recommendations. And make sure when he's drug tested, they're going to test you for levels. So the drug use had better start going down. You understand?
Yes, ma'am.
And there's going to be 90 sober meetings in 90 days. Probation, is there anything else that's needed?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
You know, you move around.
Move around and do what?
Let me talk to you about that.
All right, the warrant will be recalled that you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and sign it? All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right.
Briefly, Judge.
Yes.
Just so I understand, if he completes the parenting classes and gets his GED, that would satisfy community service?
Yes.
Thank you.
All right, thank you. Just remain in court. Probation will go over conditions with you. Oh, no problem. And excuse me, Mr. Skinner? Also, you're gonna have to pay restitution to SAPD for drug testing, okay? No, we'll have a hearing on that. Are you all ready on Jaylen Ross?
Yes, Your Honor.
Yes. Court is calling 2025 CR 004086 off the record for a moment. And Norma, Mr. Hayek is not here. Mac is here. Could you let Mac know which client that is? All right, we're back on the record. Could I have parties announced for the state? Defense?
Anita Perez for the defense.
I'm sorry, what? Okay. All right, and the court is also calling 2025 CR 0035333. And you're Mr. Ross? Okay. Counsel, each of the cause numbers, did you receive all discovery and review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Ross, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented in the cause number ending in 33? And are you proceeding on the indictment as presented in the cause number ending in 86? Mr. Ross, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
And cause number 2025 CR 0035333, you're charged with assault, family, household, impeding breath or circulation. And in cause number 2025 CR 0040086, you're charged with violation of bond or protective order 2 times or more within 12 months as a 3rd-degree felony. Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into these plea bargain agreements, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, I did.
In each cause number, did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
Counsel, in each cause number, I'm sorry, I'm just seeing who's coming in. All right, in each cause number, has your client been able to provide you with any defenses?
Yes, he has, Judge.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
In each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe so, as to both cases.
Mr. Ross, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, punishment is to be assessed at 4 years in the prison. There is a $1,500 fine. State is silent on your application. The cases will run concurrently. There's to be no contact with the complainant. And in the cause number ending in 33, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea? Defense, is that the plea?
Yes, that's my
State.
understanding.
Is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, are there any such motions?
No, Judge.
Then in cause number 2025 CR 0035333, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR 0040086, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, with regard to both cases, state offers in the evidence they consider harmless and intelligence.
Any
No,
objections?
no objection, Judge.
In each cause number, did you review the waiver and consent to stipulation of testimony with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Sure.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates. I don't see the December 6th, December 11th.
What those dates are referring to, which I guess we could figure out how to put in situations where those were days that the defendant called the victim from jail. So those would be reported to jail.
All right, so,
And we've been provided with those, Judge.
I'm sorry,
We've been provided those.
well, are you stipulating that, because he pled no contest? Is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024, and December 11th, 2024? And December 15th, 2024, December 20th, 2024, and January 25th, 2025?
The last date was not, that was the part of the report attachments where he had allegedly had contacted her through social media after the release of custody.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses. The
Well, no,
state
no, no,
can-
no. I'm
No,
trying
but
to see if
I'm
there's,
trying to get there. I'm trying to get there as to our application for, we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then
well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order. But the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR 03533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
So I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI. And just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today.
All right, in council, where are you saying this?
Can you repeat
this-
the dates, Judge?
The dates that
That they're in question?
the dates that are in question for the court are. I have a December 3rd. I have a December 5th date. So December 5th and count one, that's paragraph 1. So I'm looking for the December 6th date. I don't see the December 6th date in here. And then there's a December 11th date. I don't see the December 11th date in here. Okay, so where's the,
You can download it and put it on the disk to have as part of the stipulation. If you do.
Well, December 2nd was the date of office. I was just trying to confirm that, Judge.
well, so here's the thing. If he's not going to stipulate that what's in the indictment, the dates, then we can't proceed. I can't proceed on those dates. And if there's no additional information that's given to the court, then the court is going to find him not guilty of this because
And Hunter, if I may ask Jen's record, all that's required for the statute is 2 offenses within a 12-year period. The first offense is gonna be, is it December 5th, which is listed in the report, and then the second offense would be the January 25th date, which is in the report. So that would be 2 violations within a 12-month period, and we can scratch or amend the.
all right, so y'all want to admit, all right. So we're back on the record. Well, I don't even see the January 25th date in here.
It says January 23rd, yes.
Well, that's they have it listed as report time. I don't know if that's the report time when they made the police report or the report time for this offense. Wait, just one moment. Let me see. All right, you're correct. So that on or about date time is the time when they filed the report, but also the time when she's saying it happened. So the court will find there's sufficient evidence to find you guilty in 2025 CR 0040086. The court will defer finding of guilt as you apply for deferred adjudication. And you're saying that you wish to waive PSI?
That's correct.
All
That's
right, what do you wish to say on behalf of your client?
Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old, is that right? 16? 15. Since they were
All right, does he
15.
want to testify?
No, Judge, just let me just finish. I'm so sorry.
All right, so you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay, I'll just
All right.
proceed. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement, and if he wants to hire a lawyer and, get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today, and I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry, I was confused about the city, that there was an actual jury trial, and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim.
Due to what?
The witness leaving the state.
Okay.
So as we stand here today, we have, obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, we know that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is, let me see, his name is Eggerson is his last name, Sergeant Eggerson, and I did call the number. Let me see, on Potaranco Road. It's 11223 Potaranco Road, and unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication
Okay,
legally?
well, I would ask the court to take that into consideration, that he has no legal convictions under any other ordinary circumstances. He has no prior offenses,
Okay,
no
but
convictions. And so
But if you're
because he's a
saying he's-
first-time offender,
All right, but if you're saying he's legally entitled to deferred adjudication on this
I
case?
have no statute.
All right.
If the court, I have no statute, but I'm just saying as a matter of principle, as a matter of, mercy on my client, the court, I should hope, at least, because again, he's also been in contact with, being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that timeframe.
All right, so what I can
And
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bear County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
In each
Judge,
cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
They're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that motion.
On my behalf. Can I please speak on
I don't know
my
what you-
behalf? I just want to testify. I didn't.
Patrick Washington.
Good afternoon, Judge.
Good afternoon.
Looks like we're gonna need a trial, Judge.
All right, need a jury trial date? Jury trial? No, I need a jury trial date, 3 days. All right, June 16th.
June
Thank you.
16th. Hey, Mr. Washington. Take care.
Have a seat, sir. We'll take it right now.
Thank you, Judge. Have a good day.
You're welcome. Have a good one. Misty Portman. Justina Salceda. Are you all up here on Misty Portman?
Yes, Judge.
All right. Move with purpose. All right, so,
Have a seat.
An agreement
Oh,
later on
okay.
criminal trespass in County Court 9 and CIC this case, she'll take that to the forum.
all
Yeah,
right.
I've already gone to 9 and they're gonna recall her there tomorrow.
All right, thank you. So what we'll do is, Norma, this will be reset for tomorrow. And then if,
It all gets, all
but Deputy Laura, she's gonna go to misdemeanor court before she comes here.
Okay.
All right.
right, thank you.
You're welcome.
Excuse,
Thank
Your
you.
Honor?
Yes,
Thanks.
thank you.
See you tomorrow.
Have a seat.
Salcedo.
Hi, Judge.
All right, do you all want a jury trial?
Judge, I need to make a motion to have my client retested and reevaluated on psychological competency, Judge.
All right, you'll need to file it with Judge Rodriguez and Norma. They need to do the informal inquiry. And let me explain something to you, because a lot of people don't understand this. When you're ordered to be in court, you come to court. None of this telling the deputies, oh, I'm not coming, because at the end of the day, if I order you to be to court, who do you think is going to win the argument when the deputies have to bring you over? You think you're going to win that argument? So do not do this again where you're ordered to be in court and you say, I'm not coming. You understand?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor. Be excused, Your Honor.
Yes, so Norma, recall this case to make sure there is a setting for an informal inquiry in Judge Rodriguez's court. And we're going to recall this back for June 9th.
Thank you, Your Honor.
Thank you.
Thank you. Have a seat, ma'am. Have a seat. Thank you.
All right, I'm gonna do this last case and then we're gonna send everybody back. Michael Keating.
Ready, Your Honor? All right.
Deputy Laura.
Yes,
and
Judge.
Deputy Laura and Norma. Everybody else, they'll need to come back tomorrow. Court is calling 2025 CR 0000841 State versus Michael Keating. Can I have parties announced?
Edward Bartolome on behalf of Mr. Keating,
Are you
Mr.
Mr.
President on
Keating?
bond. Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keating, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do. Thank you, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Keating, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, I need his initial there.
Apologize.
Did you understand you're charged with burglary of habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he is and was, Your Honor.
Mr. Keating, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Yeah.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. There's to be restitution to the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is the plea, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None heard over.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There'll be 200 hours community service restitution, no contact with the complainant, and then no harmful or injurious contact with Christian Blanca's anger management in the BIPP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
And is this a family violence case?
No, Your Honor.
All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We've reviewed the documents, Your Honor. We have no objection to the attachments of the reports.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Do, Your Honor. First of all, Your Honor, my client's a national sales manager for a corporation. He travels all over the United States. He has how many salesmen now? 75 to 100, Your Honor. We've discussed this case, facts and circumstances surrounding it, Your Honor. I'm very confident that in this particular instance, Your Honor, we're not going to have a repeat of that case. One of the parties with no contact happens to be his fiance of 7 years.
So why did he do this? That's the big question.
There's extenuating circumstances, Your Honor.
All right, what's extenuating that would cause him to beat up his, I'm assuming now
He did-
ex-fiance?
Yes, ma'am.
So I'm trying to figure out what's going on, because that's what the police report says.
I know what it says, Judge. Position and posture of the individual and her at the time, the hour of the night, the general location where it was, Your Honor. The fact that she may or may not have been intoxicated at that point in time resulted in concern for her personal safety. And he acted inappropriately by kicking in the door here.
But then what about the hitting?
Your Honor, the contact was with an individual. She attempted to intervene at that point in time and things got a little out of control. But the purpose was concern for her safety and not for abuse.
All right, do you have any children?
Yes, ma'am. Both live with me, 15 and 17.
Who else lives in the household?
That's all.
And she remains his fiancee, Your Honor, after 7 years.
So she remains his fiance?
Yes, ma'am.
Does she live at the house?
No, ma'am. Not currently. Until this is settled.
All right, well, she's, they're saying no contact with her.
There was no
No harmful or injurious, Your Honor.
Okay. All right, then the complainant, well, the fiance can live back with you. I now understand what is happening. I guess the Michelle Lay Brandy Griffith person was,
Ted-
Okay.
She is not in any sort of intimate or family relationship.
all right. So do you have contact with your fiance? Is your attorney able to call your fiance today?
Yes, ma'am.
All right, so this is what the court is going to do. 6 years deferred adjudication, restitution, if any, to the complainant, 200 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the community service hours will be deemed satisfied. There's to be no contact with the complainant. There should be anger management. No harmful or injurious contact with Kristen Blancas. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home healthcare provider or with minors. And 30 days as a condition in the Bexar County Jail. And that begins today.
Your Honor,
Yes.
there's a number of things that need to be resolved for him regarding his employment, which is significant, Judge.
But he
And-
works for himself.
No, Your Honor, he does not.
Okay. Oh,
And
he'll-
my children, ma'am, it's just me.
All right, then he needs to report for custody tomorrow to the Bexar County Jail. If he doesn't report for custody tomorrow to the Bexar County Jail, then it will be a violation of his probation, and he needs to report May 22nd, no later than 5 p.m. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Can he do, Your Honor, can he
Yes.
do weekends?
No, they don't do weekends at the jail anymore.
Really? The
Yeah.
reason
Yeah,
being,
this is gonna make me lose my career.
Okay. All right, so if you'll confer with probation. Thank you.
Thank you, Judge.
You're welcome. All right, Deputy Laura, if you can take them back so we can have our jury. And they're gonna come back to tomorrow.
I just want to make
Yes.
sure
Thank you.
that we put them in our docket tomorrow.
9 o'clock in the morning tomorrow, Your Honor.
Yes.
Thank you.
You're welcome.
And I'll put her for tomorrow.
Does our attorney, it's right on my face.
Hi.
Oh, you can go ahead and go.
So, jail might have been pretty jail or anything.
No, she'll bring them over.
I guess they just did it. Okay. All right, well, 9 a.m. tomorrow. Okay, well.
Just went by where.
Okay.
I already have it.
Well, that's what I hope.
I want to take them. No, but I have more. Inmates? No.
You're on.
I know.
Yes.
Sorry.
Okay, go. Okay. Oh, no, just 1 second. I'm sorry, I was writing something in the Odyssey. All right, we are back on the record in 2024 CR 2675 State versus Darren Johnson. Can I have parties announced, please?
Megan Galloway and Andrew Edelman for the state of Texas.
William Davidson and Robert Porter for Ms. Johnson.
And are you Miss Johnson?
Yes, ma'am. Darren Johnson.
All right, and are parties ready to proceed?
Yes, Your Honor.
Yes, sir.
Thank you. Where did Mr. Porter go?
Oh, it's a chair.
Do y'all want to call Mr. Porter and tell him? Starting?
Oh,
I think he walked out this back way. And Judge, did you want our witness up on the stand?
Yes, please. Oh, there you are. Oh, we're ready.
All right, for the jury.
Everyone, please be seated and state, call your next witness.
The state calls Detective Dylan Myers.
All right, if you can raise your right hand for me, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record. Make sure you keep your voice up so that members of the jury can hear.
Detective Dylan Myers, SAG homicide unit.
All right, state you may proceed.
Thank you, Judge. Detective Myers, how are you currently employed?
I'm at the homicide unit where I've been for 3 years.
And what department is that with?
In San Antonio Police Department.
Are you a certified police officer?
I am
How long have you been employed with the San Antonio Police Department?
just over 9 years.
What type of training did you undergo to become a police officer with SAPD?
Went through an 8-month academy where we learned penal code, code of criminal procedure, traffic code, did tactics, how to handle calls, shooting drills, and fitness tests.
Okay. And then after you graduate from the academy, what's the next step in training?
We get put on patrol somewhere in the city. There's 7 service areas now, so one of those service areas usually overnight.
Okay. Prior to being at homicide, did you have any other assignments with SAPD?
When I first promoted, I had 5 years to detective. I was a uniformed evidence detective. So basically CSI, I did that for about a year. And then I went to homicide after that.
Okay, and just so the jury is aware, CSI, does that mean crime scene investigation?
For UEDI, it's uniformed evidence detective investigator. So I would take photos of family violence, for instance, collect evidence. I didn't do all the stuff CSI did. The major crimes were handled by them, but I was there as an in-between basically.
Okay. And you said when you promoted to detective, do you have to take an exam for that, or what is that process?
Yes, there's a civil service examination that you can take at 5 years on as a step C officer, 5 years. And so once you're eligible for that, you test. If you score high enough with seniority and there's vacancies, then you get promoted.
Okay. Now, your current title and assignment is with homicide, is that correct?
Yes,
And how long have you been with homicide?
about to be 3 years.
And what are your duties as a homicide detective?
I investigate 60+ offenses on the aggravated assault side of homicide. Homicide is divided into 2 sides. We call them murders and then aggravated assault side. Murders deals with the officer involved shootings, in custody deaths, and obviously murders. And then aggravated assaults has a variety of offenses, but aggravated assaults are bread and butter. They're the main thing we deal with.
Okay. Now, were you employed as a police officer on November 2nd of 2023?
I was,
And was that as a detective with the aggravated assault unit of homicide with SAPD?
yes,
Okay. And were you assigned to do follow-up investigation on a case under FAPD case number 23236613?
yes.
Do you recall how you ended up with that case?
I was assigned it by my supervisor in the homicide unit.
Okay. Once you received the case, what did you do to further investigate?
Well, first I saw that the offense had originally been written up as impeding roadway. My sergeant spoke to me about it, said that Fusion, which handles that offense, had done their investigation, determined it didn't meet the criteria for them. And so then it was passed over to homicide because he believed it might meet a criteria for an offense for us.
Okay. And so once you received the case, under that case number, were you able to look at all of the evidence that was contained under that case number?
Yes, all the body worn cameras, the in-car video, any video that's uploaded, all gets linked to that case number or that CFS.
Once you received the case, did you review the evidence that was associated with it?
I did.
And did you identify any witnesses that you believe needed to be interviewed?
No, all I had seen from the initial report was the victim and the suspect. So they had already been interviewed by a Fusion detective, but I was going to redo for my investigation, interview them again after I reviewed all the evidence.
Okay, and so did you conduct additional interviews with Mark Clanton and Darren Johnson?
Yes, I did.
All right, and how are these interviews conducted?
For this case, it was by phone.
Okay, and specifically regarding the interview with Darren Johnson, was that phone call recorded?
It was. All of our phone calls we make have to be recorded with witnesses, victims, suspects.
Okay. And did you give her a warning that the statement was voluntary and she could end it at any time?
Yes, something along the lines of you don't have to talk to me if you don't want to.
Detective Myers, I'm showing you what's been marked as State's Exhibit number 8. Do you recognize this disc?
Yes,
And is this fair and accurate, or what is contained on the disc?
I had a recording of the phone call I had with Darren Johnson.
And is it a fair and accurate depiction of the conversation as it occurred?
It was spliced a little bit in order to get rid of the unnecessary
Excuse me,
parts.
Your Honor.
Yes.
I would object to him going on any further as to what is on this.
All right, do you have any objection to State's Exhibit number 8?
No.
All right, are you offering State's Exhibit number 8?
Yes.
All right, then State's Exhibit number 8 is admitted without objection. Granted.
I got this case assigned to me regarding you and Mark Clayton. I can decide of what occurred. I was calling to try and get your side. You don't have to. Well, I'll tell you, I'll just have to tell you, you don't, if you don't want to, you don't have to tell me. I just got.
I wanted like to, I asked you if you still video.
Yes, so I just did it.
And then would you do it for the phone?
Yes. You pull up to your residence. So I saw all of that. That's from your house, right? When you did the video, did you tell me that he jumped in front of the car, right? I mean, obviously, he's in the same, he's not jumping anywhere, but I jumped when he, like, moved in front of your vehicle? Is that what you're saying?
Like he hit the vehicle with his hand and then fell back on the ground. First. Correct, the only thing I have is the video, yeah, that's true.
As you actually go and drive, you're looking from the rearview mirror on the side, right?
Correct, that's true.
So you're not sure, you can't know where he was in that regard, then if you're looking back, right?
Only from the video, I'm very much in the head, he's so crazy, you know.
Okay, yeah, and he had no major. Well, do you know how this report was originally written up? Or not?
I haven't seen it yet, and if I thought to do the report, because of the report, and
Okay, and I'm gonna show you what has been entered into evidence. That's state exhibit number 5. All right. If you could just explain to the jury what we are seeing on the state's exhibit, and you can use the big screen if you need.
This was the video provided that was already uploaded in evidence.com of the incident in question.
And so we see some movement over here in the trees, and then if you can just explain to the jury what you observed.
So it appeared to be Miss Johnson moving the bins over there, and then Mr. Clanton coming out and moving the bins back.
Okay, and then what are we seeing right now?
Mr. Clanton bringing the bin back out to the curb.
Yeah, I'm just gonna go back a little bit. Are we able to see the defendant driver's side door on this video?
Yes, it's near the top left. You can see it behind the branches.
And is that right here?
Yes.
And are we observing the door shut right here?
Yes, you can see Miss Johnson getting back into the vehicle and the door shutting.
And then who is that we are observing coming into view?
Mr. Clanton.
Okay, and what are we observing occur with the truck?
It's beginning to move again.
And where's Mr. Clanton in the video?
Right on the edge of the curb.
Is there anything significant about the tires on the truck?
So before that, you can only see the bottom of the rim. You can't really see the bottom part of the tire. At this point, you can see the tire, which led me to conclude that the tire had gone up onto the curb at this point. And then at that point, it appeared to have gone back off of the curb because you can no longer see the bottom portion of the tire. You can only see the bottom of the rim.
Oh. And so as part of your investigation, after you took statements from Darren Johnson, and Mark Clanton. I guess I want to talk to you a little bit about her statement. And so in the statement, did she tell you that she had heard Mr. Clanton come outside?
Yes,
Okay, and that he was actually speaking to her at some point, is that correct?
she said he was yelling something about the cans.
And at this point, when you spoke to her, the offense date is October 21st, 2023, is that correct?
Yes,
But you speak to her days later on, November 2nd of 2023, is that correct?
no, it was around the time I got it.
Okay. And, just regarding the statement that she made to you at this time, she states that she wasn't actually looking forward when she put the car in, or the motor vehicle in drive, she was looking backwards, is that correct?
Yeah, she said she was looking in either the rearview mirror or the side mirror. And at one point, she says the rearview mirror, looking at the cans that were now behind her.
Now regarding where the trash cans were depicted on the state's exhibit, are you able to observe this cinder block line right here?
Yes,
Okay, and do you know what that is?
the dividing line of their properties.
Okay, and so the trash bins were on the left side of the dividing line in front of the Clantons residence, is that correct?
They appear to be from the angle of video.
And so in your training and experience, I mean, is a person able to use force against somebody to move trash bins?
No,
And in your training and experience, I guess you said you worked homicide and aggravated assault cases, is that correct?
yes,
And in your training and experience, is it possible for a motor vehicle to be used as a deadly weapon?
yes.
Now, after you conducted your investigation, what was the result of your investigation?
I changed the offense to aggravated assault deadly weapon, and I switched victim and suspect, because originally Mark Clanton was written up as a suspect of impeding roadway, obstructing passageway. And I switched it for Darren Johnson to be the suspect in aggravated assault deadly weapon, and Mark Clanton to be the victim.
Okay, and why did you do that?
Because just from watching the video and from her statement, from looking in the rearview mirror, even though from the video, you can see her re-entering her truck. When you re-enter the truck, you face the truck. She had to have seen Mark Clanton walking by with the trash can at that point, and then popping up onto the curb while he's bringing the trash can back out. I believed it to be causing bodily injury recklessly.
Yeah, you're just making assumptions here and speculations.
Sustained. Ladies and gentlemen, you disregard the last answers.
We passed the witness, Your Honor.
Detective Myers, you got this case about 11 days after the incident, is that correct?
Yes, sir.
And so you weren't there when this happened, correct?
No, sir.
And when you watched this video, did you notice this whole thing that we just talked about over a period of several minutes happened in less than a second? Did you notice that?
It went really quickly. I just
It
slowed
went
it down.
quickly, didn't it? Yeah.
Yes, sir.
And are you able to see more slowing it down, or do you see it all at the normal pace?
You can see more slowing it down.
I understand. What is this?
A water bottle.
You see any water in it?
Yes, sir.
Okay. Now, when I cover up this water, you see water in it now.
No.
If I raise this, do you see water?
Yes.
Why do you see water now and not then?
It's my perception of where the bottle is in comparison to the folder covering the water.
Okay, so this is covering the water, correct?
Yes, sir.
And if I pull this down, you see the water, correct?
Yes, sir.
And the same event happens if I pull this up, correct?
Yes, sir.
But they're two different actions, correct?
Sure.
And did you go out to the scene?
No, sir.
And you're a detective, you don't think it's important to go out to the scene?
We don't go out to every scene, sir.
You go out to some scenes?
We do go out to some scenes, yes.
So for a second-degree felony, it's not important to go out there and check it out?
I had the evidence that I required.
Oh,
for this
really?
case.
Really? Then you can tell me about the curb. Tell me about that curb.
For the curve of the curb,
Yeah,
I couldn't tell you the exact grade of the curve or what degree it is. I
and that
don't bring a
doesn't matter.
protractor out.
I'm sorry. Go ahead.
I don't bring a protractor out to scenes. That would be a TID thing.
Did you talk to TIE?
Yes, they're actually in the same office.
Okay, and what did they tell you?
That this does not meet an accident, that it meets an aggravated assault.
I'm not asking you about that. I'm asking you about the curb that you say you know about because you're an investigator.
I said that I don't measure with a protractor, a slight curve in the street.
Okay, so you say you saw the water, then you didn't see the water. I'm going to show you State's Exhibit 1, which has been entered into evidence, and ask you if you recognize this. Defense, I'm sorry. You recognize that?
That's the area where it happened.
Okay. Anything different about that curb?
The curve goes down a little bit.
It does. And if it goes down, that allows you to see the tire, correct?
That would be one way, yes, sir.
Okay. Now, you called Mark Clanton first and then my client, correct?
Yes, sir.
Did you warn Mark Clanton like you did my client?
No, sir.
Why not?
At that point, he already wasn't a suspect of the obstructing roadway.
So you already made your determination before you made these phone calls.
I didn't make that determination. The fusion detective made that determination when he said he wasn't a suspect of an obstructing roadway.
Now, the state asked you about, or you mentioned she kept telling you she was looking in the mirrors and stuff like that.
Yes, sir.
Isn't it true that you were more or less saying, weren't you looking in the mirrors and you were leading her to say what she said?
No, sir. That was the first thing she said.
Okay.
I asked where she was looking, and she said in the rearview mirror.
And the jury can hear that for themselves and determine that.
Okay.
And these are the only two witnesses you interviewed.
Yes, sir.
Just a minute, please. Now, based on the time that you looked at the video the first time and now, you don't notice any tampering, is that correct?
With the video,
Yes.
no, this is the same that I viewed.
Okay, thank you. Now, you stated earlier you didn't go out to the scene, correct?
Yes, sir.
And so you don't know the distance between the houses or the driveways, is that correct?
I couldn't tell you the measurements, no, sir.
Yes, Liz.
No further questions.
All right, is this witness excused?
Yes, Judge.
Great, you may step down. Please leave the exhibits behind. State, call your next witness. Yes.
mention, I guess this is kind of two parts since we're just gonna go over her testimony. I did have something that I wanted to ask her about, and then I would make argument to the court about.
All right, so this is the way I'll handle this hearing. I'll hear what the questions are. Let me hear what everything is, and then at the end, I'll allow everyone to make their objections. Because the only way for the court to determine if testimony should be given to the jury is if I hear everything. All right, Miss, if you'll come up here, please. All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Just make sure you keep your voice up so that everyone can hear, all right? All right, if you'll state your name for the record.
And it's Ina L. Clanton. Z-I-M-A.
All right, state you may proceed.
Ms. Clanton, how old are you currently?
76.
And what county do you currently live in?
I live in Bear County.
And how long have you lived in Bear County?
31 years.
And do you know Mark Clanton?
Yes, he was my husband.
And how long were you all married?
56 years.
Do you know why Mark isn't here today?
I'm sorry.
Why is Mark unable to be present in this trial?
He passed away on March the 7th.
And what is that, 2025?
This year, yes.
Now I want to talk to you about the date of October 21st, 2023. Do you recall that date?
Yes, I do.
Okay. And there was an incident that occurred involving the defendant in this case and your husband, is that correct?
Yes.
Okay. And you were not outside to observe the collision of the defendant's motor vehicle into your husband, is that correct?
I was not. He hollered at me and said, she's moving her cans.
Okay. But after the fact, you were able to walk outside and observe your husband, is that correct?
Yes.
Okay, and I'm gonna show you what has been entered into evidence as State's Exhibit number 3, I believe. And so, are you able to see it on the little screen? If you're not, you can turn around and look on the big screen.
I can see it on this screen.
Okay. And so, you recognize that person depicted on the screen?
Yes.
Who is that?
It's my husband, Mark Clanton.
And do you know how old he was on that date?
78. He had just gotten out of the hospital.
And do you recognize this person in the white shirt right there?
Yes, that's myself.
Okay. Now after the police left the location, were you able to observe Mark and see if he had any injuries?
Yes.
And did you take photos of those injuries?
Yes, I did. On different days.
Okay. I'm gonna show you what's been marked as State's Exhibits 9 through 17. If you can take a look at these photos and tell me if you recognize what's in them.
Yes, that one's my house.
State's Exhibit number 10.
Is Darren Johnson's house and her truck.
State's Exhibit number 11.
This is Darren's house plus is where I had put the cinder blocks to differentiate where the boundary line was on the property, because Darren had removed the sticks that the survey team had placed.
Okay. And then what is this?
That's my mailbox.
Okay, and just for the record, what is your address?
13907 Blairwood.
Further back, is that correct?
Yes,
Now, State's Exhibit number 13, can you tell me what that is?
that's knee. Knee or elbow.
Okay.
It's his knee because his pants are.
Okay, and what is this right here?
It's a scratch and a scrape from Darren hitting him with the truck.
And State's Exhibit number 14.
That's the bottom of his foot where his shoe had rubbed when he hit the grass.
And then State's Exhibit number 15, is that a healing wound?
Yes, it's a knee.
And State's Exhibit number 16.
And that's his arm that had been bruised.
And then State's Exhibit number 17.
That's his left foot where there are abrasions and redness.
Now I'm going to show you what has been entered into evidence as defense exhibit number 1.
All right, just one moment off the record. All right, you may continue.
Okay. So regarding defense exhibit number 1, do you know what that is?
Yes, this is about 4 or 5 feet from my mailbox. It's an area where the water repair truck had come in several years earlier, maybe 12 or 15 years. And they had pressure, I don't know what they're called, pressure stabilizers that kept the truck in one place. One is over here to the right, another over here to the left. And as they did their work, they call this the side, this curb itself went down, and the city had never repaired it.
Okay. And how long have you lived at your home on Clearwood Drive?
Since 1991.
Okay, and you and Mark both lived there?
Yes.
And then just regarding an incident that occurred back in 2021, do you recall an incident that occurred back in 2021 involving Mark and the tree and the defendant?
Darren Johnson had a habit of cutting our trees, our crepe myrtles in the backyard. She claimed that the petals were going into her pool, and it was too much of a hassle for her to have to take them out of the pool. So she virtually massacred our trees. We were out of town over July 4th weekend, and she had cut the trees She had a saw. When we did notice that she was cutting the trees, we approached her and asked her to stop. She would not stop. She told me she was a lawyer, and that I needed to call my lawyer. And she continued to move her ladder down the side of the fence, cutting a foot to 2 feet past the fence line.
Sorry.
And then she was cutting, and then she cut my husband with a saw. And she was arrested for criminal misdemeanor.
A misdemeanor offense. Okay, and just regarding that incident with her cutting Mark, did you observe any injuries on him on that day?
Yes, she had cut the back of his hand.
Okay. We passed the witness room.
All right, so if you could step down, please. Hello. If you'll just take a seat back up here, please. Just one moment. And there should be a square microphone up there. If you'll put that somewhere on your jacket, just click it. All right, thank you. And so that both parties are aware, I'm just going to swear her in again.
Judge, and she's been admonished, but I don't know if the court would like to admonish her of the ruling or.
All right, so here are my rulings, just so you'll be aware of them, all right? So you are not allowed to testify that your husband had just been released from the hospital, so don't testify about that, okay? And you're not allowed to talk about the reason why he was moving the trash cans, okay? So to be on the safe side, anything that he told you, if that's where you're getting your knowledge from, you're not allowed to testify to, okay? With regards to the injuries that you say that he had, you're not allowed to say that those were injuries from getting hit by a truck, but you are allowed to testify and say, you know, if there was an injury to his knee or an injury where else, you are allowed to say that there was an injury here or there, just with the photographs that you took, okay? But you're not allowed to say that the defendant caused those injuries or that a truck caused those injuries. And the reason for that is it has to be something that you've personally seen, all right? That's why it's being done. So there are rules in criminal cases, all right? And let me see if there's anything else. All right, with regards to the survey, you know, you mentioned that there were survey sticks. You are allowed to say, you know, if you saw the survey sticks being placed by the people who are in charge of surveying the land to give the boundaries, you're allowed to testify to where those stakes were. You're not allowed to testify if you're saying the defendant removed those stakes or pulled those up, you're not allowed to testify to that, okay? Is there anything else that I've missed from either side?
No, Judge.
No, you don't.
All right, so the other thing is when you're testifying, if either of the parties stand up, that means that they're about to object to something. So just stop talking and I'll make a ruling. And if you don't know whether or not you can answer it, just ask me, okay? All right, let's bring them in.
All right, for the jury.
Oh, you can have a seat. We're waiting on the jury. Seat.
You want them up?
No, they can sit here. Everybody, please be seated. Yes. One more. I'm sorry. Oh, okay. So do you all want to go back and wait in the jury room? And oh, okay. All right. So anyway, everyone have a seat. We're not on the record. Sometimes people would feel more comfortable if everybody's not sitting here waiting for them to come back from the restroom. So maybe it would be best and they would feel okay if you all were in the jury room, and then we'll bring you all back out, okay? All right, everyone, please rise. Everyone, please be seated. I'm going to swear you in again. So if you can raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? I do. All right, you can lower your hand. Make sure you speak up so that the members of the jury can hear. If you'll state your name for the record, please.
My name is Ina L. Planting.
All right, state, you may proceed.
Ms. Clanton, how old are you currently?
76,
And what city do you currently live in?
San Antonio,
And how long have you lived in San Antonio, Texas?
since 1991, so that's 34 years.
And what is your current address?
13907 Flairwood Street,
How long have you lived at that address?
since 91, 34 years.
Okay. Do you know Mark Clanton?
Yes, I do.
How do you know him?
He was my husband.
And when you say was, what do you mean by that?
He passed away on March the 7th this year.
I'm very sorry for your loss. Now, what was Mark's date of birth?
December 20, 1944.
And are you currently employed?
Me, no.
Okay. What did you used to do for work?
Well, I've done various things because my husband was in the Air Force. I've worked for an attorney. I worked in a art gallery.
At some point, were you a teacher?
I taught jazzercise.
Oh, okay.
My husband was a teacher.
Okay.
And in that 1991, when we returned, I worked with a company called Independent Horizons. And they housed disabled adults. And I was responsible for 60 adults in their medical care.
Okay. Thank you for that. Now I want to talk to you about October 21st of 2023. Were you living at your residence on Flairwood Drive on that day?
Was.
And who was living with you at the home on that day?
My husband, Mark.
Okay. And was there an incident involving Mark where you had to go outside?
Yes.
Okay. And once you were outside, what did you observe outside?
I observed my husband flying through the air and landing on the ground, on the grass.
Objection, Your Honor.
Well, I'm gonna ask if we could approach.
But you-
Approach.
All right, you may proceed.
Thank you, Judge. And so I'm going to show you what's been entered into evidence as State's Exhibit number 3. Do you recognize that individual?
Yes, my husband, Mark.
Okay, and do you know how old he was on October 21st of 2023?
78.
And so I've paused State's Exhibit at the 3-minute and 4-second mark. Who is this individual in the white shirt?
Myself.
Okay. Now, after police arrived, responded to the scene and left, did you have the opportunity to observe Mark's person?
After the police left?
Yes. And did you observe anything on his body that was not there before you observed him laying on the ground?
He has scrapes on his knees, on his knee, sorry. The bottom of his foot, the side of his foot. He had bruising on his arm. And later he complained of having some pulled muscles in his back.
Okay. So I'm going to show you what's been marked as State's Exhibits 9 through 17. Can you please take a look at these and just tell me if you recognize them?
This one is my driveway, my house.
Okay, so we're gonna look at them all together and then I'll ask you. Okay. Do you recognize all the objects that are contained in State's Exhibits 9 through 17?
I do.
Okay, and are they a fair and accurate depiction of what's depicted in the photos?
Yes.
At this time, I'm tendering to defense for inspection. Judge, at this time, the state offers states 9 through 17, understanding the court's previous ruling regarding. Permission to publish, Your Honor.
Granted.
Okay, Ms. Clanton, can you see State's Exhibit number 9?
Yes.
And what is depicted in State's Exhibit number 9?
Are 2 cars in the driveway. That's me standing in the doorway.
And is that your home?
That's my home.
Okay, and that's 13907 Flairwood Drive, correct?
Yes.
All right, regarding State's Exhibit number 10, what is depicted in State's Exhibit number 10?
This is Darren Johnson's home, 13903. With 2 pickup trucks. 1 on the street and 1 in the driveway.
And what is this item that I'm pointing at?
It's my mailbox.
Okay, and what is this right here?
It's a curb of the street.
Okay, is there anything significant about the curb right there?
I don't remember how long ago, but my previous neighbors had a water leak over by their mailbox, which is on the other side of the truck. They had brought in a very large truck to help repair. And they had these stabilizers that kept the truck in place while they were digging a hole, I believe. And at the same time, the side by the street was pushed down and was never repaired.
Okay, thank you. Regarding State's Exhibit number 11, is that your mailbox depicted right there?
Yes.
And is these cinder blocks that we see, is that a property line divider?
Yes.
Okay. I'm showing State's Exhibit number 13. Do you know what that is?
It's my husband's knee.
And is that a photo that you took after you observed him laying on the ground on October 21st of 2023?
Yes.
And State's Exhibit number 14, is that the injury that you described observing on his foot?
Yes.
State's Exhibit number 15, is that another photo of a healing wound contained on the knee?
Yes.
And State's Exhibit number 16, is that the bruising that you were talking about earlier?
Yes.
And then State's Exhibit number 17, is that the injury that you were speaking of on Mr. Clanton's foot?
Yes, on the side.
We passed the witness.
Defense.
Hello, Ms. Clanton. My name is William Davidson. I represent Ms. Johnson. Just have a few questions for you. When this incident happened, were you inside your house?
I was inside, I heard Mark yelling at Darren, asking her why she was moving
Non-responsive, Your
our
Honor.
trash
I'm
cans.
sorry. That objection will be sustained. Ladies and gentlemen, you disregard the last answer.
I'm asking you a specific question.
I was in the house and I was out of the house.
I'm asking you, when the incident happened, were you inside or outside? At that moment,
At that moment, I was inside, on my way outside.
and you don't need to shake your head at me. Now, let me ask you this. Would it surprise you that none of the officers on the scene listed you as a witness in the case?
No, I'm not surprised at all. There were 6 officers that were there. They were all running around. They didn't know what was happening. And as you know, your client is very.
Hold on, Your Honor. I don't need to hear do anything but answer the question.
All right. The way everything works is they'll ask you a question, just answer their question if you can. And then the state, if they have more questions for you, they'll have a chance to answer you more questions, okay? All right, you may proceed.
Yes, witness, Your Honor.
No further questions.
All right, is this witness excused?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. If you'll leave the little microphone behind. All right, state, you may call your next witness.
The state rest.
All right, defense, if you'll approach and state if you approach, please. All right, state you rest, is that correct?
That's correct.
Defense, you may call your first witness.
Your Honor, the defense rests.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes, Your Honor.
All right, ladies and gentlemen, what's going to end up happening is I'm going to have you all tomorrow here at 9 a.m. At 9 a.m., what will end up happening is both sides will be able to present to you their closing arguments in this case. Remember my previous instructions. Do not think about this case outside this courtroom. Do not start deliberating internally with yourselves or with each other. Do not do any investigation. Do not Google anything. Do not look at anything. So the plan is for tomorrow. I will read to you what is called the jury charge, and then both sides will have a chance, if they choose, to give their closing arguments to you. All right, any questions before I release you? All right, same things apply. It's going to be Thursday tomorrow, so the same number of jurors will be here at this time. All right, everyone, please rise for the jurors. Everyone, please be seated. All right, Ms. Johnson, if you would like to leave, you're more than welcome to leave. We're going to discuss the jury charge, and then tomorrow we'll put on the record if there are still any objections. But this is usually very tedious and it lasts a while. You're welcome.